The Supreme Court has declined to hear the appeal of a former West Point cadet who said that she was raped at the academy. Justice Clarence Thomas issued a dissent saying the court should have taken the case to correct decades of injustices. NBC News Justice correspondent Pete Williams joins us now from Washington. Pete, can you walk us through what the court has said on this, on both sides?
Well, there's only one side, and that's the dissent here. This case was actually goes all the way back to 2010 when a female cadet at the U.S. Military Academy, West Point in New York, said that she was raped by a classmate when they were out for a walk one night. She eventually left the academy. She said she was devastated by it, and she filed a lawsuit claiming that the academy administrators weren't properly engaged in really trying to resist sexual assaults and didn't take it seriously, didn't have the right policy or training. But consistently, the lower courts have tossed her lawsuit out for this reason. 70 years ago, the Supreme Court said that military people cannot sue the government, can't sue the military for anything related to or incident to their military service. Now, what Justice Thomas says here is that that's not the way it's supposed to work. Normally speaking, you have to get a permission to sue the federal government, and that comes from a federal law called the Federal Tort Claims Act. And it says military personnel cannot sue the federal government for injury claims arising out of combat activities in wartime. And if you think about it, that makes sense. If any soldier who's wounded in combat could sue the government, where would we be? But what Thomas says is that the Supreme Court has taken this way beyond what the law says, anything incident to. And he's also saying, how is getting raped incident to military service?
Well, Pete, this is something that has drawn criticism over the years from both liberal and conservative justices. What are the chances that this issue is revisited by the court?
Well, you're right. It's, conservatives like Antonin Scalia, liberals like Ruth Bader Ginsburg and John Paul Stevens all said they thought this case was wrongly decided and should be revisited. I guess there are two counts against that happening. One is it's an old precedent, 70 years old, and the way that this theory of stare decisis works is the longer a decision has been on the books, the longer the lower courts depend on it, the more reluctant the Supreme Court is to reverse it. It doesn't mean things can't be reversed, but that's one factor. The second factor is the court is very reluctant to get involved in the military's business. And so for those two reasons, I think the Supreme Court has consistently declined to take this. Thomas has been pretty outspoken. He said, and I think in another case in 2019, the court should have taken the case. This is the most recent, some pretty strong facts here. He said, you know, think about this. If a civilian and a soldier are standing in the Pentagon parking lot and they get hit by a bus, the civilian contract employee can sue, the military service person can't. He says that makes no sense.
All right. We'll leave it there for today, anyway, on this issue. Pete Williams for us in Washington. Pete, thanks.
Hey, NBC News viewers, thanks for checking out our YouTube channel. Subscribe by clicking on that button down here and click on any of the videos over here to watch the latest interviews, show highlights, and digital exclusives. Thanks for watching.